Hello, everyone. It's Friday. We made it, Martin. We made it. It's the end of the week. We're here the weekend. Nick Chavez here with Chavez and Valko, your key to immigration solutions, with my law partner, Martin Valko. How are you doing, Martin?
Doing well, Nick. Doing well. How are you, my friend?
Doing great. Doing good.
Good to be back.
Yeah, good to back. You were in Europe, and I was in California, and having a much needed break. But not so much of a break when we're keeping an eye out on the latest immigration developments. And we're here to bring you the latest news with respect to this new parole program, parole-in-place, or people are calling it PIP. And so we're going to talk about, what's it about and what are the requirements and so forth and so on. And as the name of our show suggests, we're here to answer any of your immigration questions that you might have. Ask an immigration lawyer, right? And you have two right now with you, and we can do it live. You may have a question about this new parole program, as I mentioned, or it could be about DACA. It could be about employment-based. We have Martin here who has a lot of years of business immigration experience. So if you're watching and you're feeling it and you have this urge to ask a question about your case, go ahead and ask away. Or if you're watching later, you feel free to comment and we'll try to respond to it. But before we begin, we are closing in on having 5,000 subscribers on YouTube, so please help us reach that mark by hitting subscribe, and by subscribing, you'll be able to get the latest news about the parole program. You'll see that we share our insight not only on that program but on other immigration topics, and you'll receive also alerts about our shows. And just want to add one more thing. I mean, one of the comments that we've received from our watchers is that we are educational, we are informative. We like to explain the ins and outs of immigration law. We just simply don't say, no, you can't do it. Well, we try to explain it, right? Why is it that things are the way they are? Why are you not eligible, or why are you eligible? So we try to explain the law. Immigration law is very complex, and we try to simplify it, and that makes us really happy. So thank you for that. And so, Martin, as a refresher, the parole program, was announced in June to help certain immigrants that are living here in the United States. They've been living here for such a long time, and they're married to U.S. citizens. They have families, and they're looking for a way to apply for a green card, but can't, at least not here in the United States, because they had entered without inspection. And so this program aims to solve that by granting them a temporary status, upon which later they can then apply for a green card if they wish to do so. And real quickly, just like what I did with the Spanish show, some of you guys know I like to draw and doodle and all that. And so this is the latest. These are the basic requirements, at least what we know with respect to parole-in-place. We know that one of the requirements is that you must show that you've entered without inspection. That means if you entered with a visa or with another form of an entry permit or even parole, you would not qualify for this parole-in-play. This is basically for those who entered without inspection. And we call that EWI in our immigration world. So when you hear EWI, that means entered without inspection, that you're married to a U.S. citizen. You're married to a U.S. citizen as of June 17th. If you marry later, and we'll talk about that a little later, if you marry after June 17th, then you're not eligible. There are some exceptions or arguments that we can look at. As of June 17th, you also have to show that you have been living here in the United States for at least 10 years, present here as of June 17th. And there's some question marks here that I have, no disqualifying crime. So what does that mean, right? And then we have this other requirement that we saw at the beginning, but it seems like, I don't know, it's a question mark. Do you have to show that you're admissible for a green card? Meaning there's a list of disqualifications under the law, and they call them grounds of inadmissibility. And if you fall under any of them, you're ineligible to get a green card. Are they going to apply that here? So, that when we talk about permanent bar, that's what we're talking about. So leave a question mark there because we don't know yet for sure. And then the last requirement is that it's discretionary, which means like even if you even if you meet all the requirements, immigration has the right to say, you know what, you seem like a bad person. You know, you're not paying your child support, or there's a lot of unpaid tickets here, and they can deny it based on that. Okay, so the latest that we know right now, Martin, is that the parole-in-place, we know that it'll start accepting applications. At least that's what they told us, right? August 19th. But to date, and I just checked maybe 30 minutes ago, as of today, August 9th, Friday, USCIS has yet to publish information about the filing process, and that includes the forms, and we don't even know what the form will be. We have ideas, but we don't know for sure. Filing fees, we don't know what the filing fees are. So, Martin, I mean, in the meantime, what should applicants be doing in terms of getting ready for this?
Yeah, as you said, we're still waiting. Forms were supposed to drop on August 1st, and then the message was that it's going to be closer to the 19th, which is a Monday from next week. Just, what we're telling people: do your homework. You know the basic requirements about being married on June 17th of 2014, being here for the last 10 years. So physical presence from June 17th, 2014 up to the point of application. So basically just start collecting those documents, whether they are pay stubs, whether they are vaccination records, whether there are school records, anything and everything with your name on it, utility bills, insurances, various types of insurances. You basically just kind of start with maybe one big pile and then start organizing them into some, different years. So you're satisfying that year, that month, sometimes, from the previous processes that we've been associated with. You could start looking at every other month, every third month. You basically just want to see what you have and see if you qualify. Obviously, proving that you can't prove that you entered unlawfully, for example, but you know that you didn't enter it lawfully, or you weren't paroled. So you're meeting those requirements that you have and we have on our social media and our website and in our app. So that's basically, you start doing that. You start doing your homework now and start preparing. So when the forms drop, then you work with attorneys, law firms, or yourself, and you put it together and you follow the instructions to submit the request, the application.
Yeah. We got a question here from Jason Bourne. Jason
Bourne
gives us little information. Yeah, that's great. So he asks, does he qualify here for a parole-in-place? He's talking about that. He was brought here at age 1 when he was 1 year old, and he's been here pretty much all his life. And he's finished high school, college. He's 21. He's never left the country. He's married with daughter, and let me see here. Jason, I assume that you're married to a U.S. citizen. And also curious to see if you have DACA. You might have been too young to apply since you're 21. Well, that's another question that we have generally for clients. But it looks like he kind of checks off all the boxes, doesn't he, Martin?
It seems like it, right? Presuming that it was one entry, that there were no other entries involved, and you're married to a U.S. citizen. You were married to a U.S. citizen spouse on June 17, 2024, and are otherwise admissible, as Immigration had it on their website. We couldn't find it earlier with Nick, so they're kind of moving around. They've added subsections. So based on what you're telling us now, it appears that you might be eligible.
Yeah. That's great. And it's basically the requirements here is entered without inspection. Again, here's my little diagram or list of things. Entered without inspection. He came in when he was 1. It didn't come in with a visa. He's presumably married to a U.S. citizen as of June 17th. and it looks like he's been here for 10 years, physically present. What we don't know, right, and most of these clients, most of the people that watches, we're only talking about stuff that looks on its face, the person might qualify. But as we tell our clients, right, sometimes there's more than meets the eye. We have to meet with them and talk about their backgrounds. Maybe they've had some issues in the past. Maybe they were deported. And then we get into this where there's some question marks right now. We don't know for sure what immigration has in mind in terms of what does it mean to have a disqualifying criminal background? What does it mean if a person has been deported? Are they eligible? So those are things that we're kind of monitoring right now. Let's see here. We do have some questions that are usually raised by our clients, and one of them has to do with common law marriage. This is what we talked about. Common law marriage, again, you have to show as of June 17th that you were married, but we have clients right now that are calling and say, look, Nick, I've been together with my partner, and we have kids, we live together, but we just haven't gotten around to getting married. Is there a way to show that they are married without a marriage license? And what say you, Martin?
Well, Texas is a common law state. So speaking of Texas residents, they or he or she may be eligible. But if the question is, hey, we've been around, we haven't gotten married yet, that it's a telltale that even in the common law state, if you haven't agreed to be married informally as a common law couple, that you may not be eligible, or he may not be eligible. So it just comes down to, was there an agreement? Did the couple agree to be married? Did they hold themselves out to the rest of the world as a married couple? Did they do things that married couples do? So, and you could backdate it. We do it in cases for various types of cases, classifications and stuff. So it depends. But if somebody says, hey, it's July, or it was June 17th, and said, well, we haven't gotten married yet, that could be a telltale that you weren't married in June 17th. But once they know the requirements, perhaps they were doing certain things and they held themselves out to be married, so the point is that there doesn't have to be a marriage license, or that was issued to be eligible.
Right, and it depends on the jurisdiction. Luckily we're in Texas, and Texas recognizes common law marriage. And I had a client who was in the same situation here, where he's been with his wife for many years. They have children. It's just that they haven't gotten around to getting a marriage license. And what I advised him to do, based on his situation, is to go down to the courthouse here in Texas, really any courthouse, and request an informal marriage certificate. And you would make an application for that. And the informal marriage certificate basically says, that's what it says on the heading. Informal marriage certificate is just as good as a marriage license, and immigration will respect that. And we're going to do a show on this, so we'll put it on the screen how it looks like. Right underneath it says, well, okay, did you meet these requirements? And you have to check the box. Did you agree to get married? Are you living together? Have you represented? And when all these things happened, that's when the date of marriage is, and you can have you can backdate the marriage prior to June 17th, and you would meet that requirement. But it just like with everything, it's important to talk to a lawyer. There might be some situations where a client doesn't want to do that because of tax reasons or something. So it's important to discuss that with a lawyer. We have a question here from Abigail. Abigail from YouTube. Hello, Abigail. She's a U.S. citizen, married. The husband's been here for 24 years. They have 2 children. And he's had a problem. Okay, and that's what we always talk about. Right? We always talk about those things. Well, he's can he apply for parole? And he came in with inspection. So far, checks off. Came with without inspection. So that is one requirement that's met. Married to a U.S. citizen, and he's had a problem 12 years ago. And so that's where we have to kind of figure what kind of problem. There are some situations where we kind of know, just based on our experiences, that this person's not going to qualify. It just depends on what we're talking about. Like with DACA, they might come out with a list of things that they're not going to even consider the PIP application if the person has been convicted of certain offenses. And for DACA purposes, they list them out. I mean, it's like it's like your serious stuff, right? Drug distribution, sex exploitation, abuse, domestic violence. Where it kind of catches us off guard is the DWI, right? Because you flip that and you could apply for a green card even if you have a DWI, but you can't do that with DACA. So it remains to be seen what USCIS is going to do with that. If they're going to apply the grounds of inadmissibility or not. But thank you for your question, Abigail. I mean, if you wanted to discuss it further, if you want to talk about this, this is what lawyers are here for. We'll be happy to discuss the background here and see if this is something that your husband would be eligible for. Thank you for your question. And let's see here. The other thing we wanted to talk about is, Martin, has to do with what I just mentioned here with the permanent bar, right? A lot of people talk about this permanent bar, and if they're wondering if they're going to be eligible to apply for a green card. Real quick, the permanent bar, what does that mean? The permanent bar, just in general, okay, I'm simplifying it here. There's exceptions. Don't take this as advice, but in general, the permanent bar is like after 1997, April 1st, 1997, if the person had entered the United States and stayed here for a long period of time, we're talking about a year or longer than a year, without any status, and they leave the country and then they re-enter. It's the re-entry point. It's that triggers this bar. And this, if you are subject to this bar, then you are generally ineligible to apply for a green card. A lot of our clients that we've seen in the past are subject to the permanent bar, and we have to look at other options, whether it be a U visa or DACA. Same thing happens if you entered and were ordered deported by a judge or by an official along the border, and you have a restriction from re-entering, but you re-enter regardless, and that upon your re-entry, that triggers that permanent bar. What do you think, Martin? I mean, that's the $1 million question. It seems there is that going to be a requirement or a disqualification for the PIP program?
Can you look at my crystal ball? I think your guess is as good as mine. If we're looking at DACAs, I'm not DACAs, but if we're looking at military paroles and other types of discretionary reliefs, it doesn't look like that PIP could be granted, but that's what I just said earlier, right? There was one of the bullets that we initially recognized was that person in order to get a parole, person has to be otherwise admissible. We can't find it on their website right now, so that's why they're going to give us more guidance. But let
me pull that up real quick so
okay.
people can know what you're talking about. Let's see here. Let's see. Yeah, can people see that? Maybe. Okay. Well, anyways, what we're talking about is this part right here, where it talks about if the parole is granted, non-citizens who are eligible to apply for lawful permanent residence based on their marriage will be able to do so without having to leave the United States. So we're looking at that and see, what does that mean? Does that mean that you could apply for your parole in place, and let's just say that you're ineligible to apply for a green card because of the permanent bar, do you just keep the parole, and is it a requirement that you have to show that you're eligible to apply for a green card in the first place? And that's the language that we're looking at.
I mean, if you want to look and if you want to look at it from the position that you want to grant parole to as many people as possible, because think about it, when you get a parole, you get it for 3 years, and that allows you to apply for a work permit, and that allows you to apply for a driver's license, a social security number. So that in a sense, I don't want to use the word legalizes you, but makes you state or you're being granted stay with authorization, with some type of legality, right? Because that allows you to go and do these things that are important when you try to apply for a job and do other things. So that's important. And so it just, if they want to accomplish that, then they may look or they may look for it. And they'll just may say like, look, we'll deal with admissibility at the adjustment of status stage. But if they want to kind of filter through the people initially and not give them the benefit of parole, then they wouldn't get grant parole. But again, like you said, we're waiting for more guidance, and that's why it's so important is just to wait and look at it. And even with DACA, I mean, there were rounds of clarifications of FAQs. Yeah. They've updated it like on this date and this date, because even they are not seeing, or I mean, don't have all the scenarios that we're going to be seeing, and there will be questions posed. And I think then they'll answer them and make the clarification as the program rolls along.
Yeah, you know what stumps us, and I did a post on this. You can check it out on the channel, on our news feed. Basically, you know, what stumps us is that, look, parole in place is not something new. I mean, we've seen this already. We've seen it in the context of they call it military parole in place. So if you had entered without inspection, but your family member, close family member, is a member or a veteran of the armed forces, military service, U.S. military service, they could apply for this parole in place, which they then grant. And if you grant it, then the second step would be to apply for your green card based on whatever family relationship you have or the petition. And if you don't qualify, they told us there in a memo. They said, you know, in a footnote too, it's if you are subject to this parole in place is really going to cure the fact that you entered once, that you only entered the United States just once, but not necessarily if you had gone back and then re-entered. So that's why people have been denied. And then they said, instead of applying for parole in place, if you're not eligible for parole in place because of the permanent bar, they give you another alternative, and that's called military deferred action. And so for those who are subjected to the permanent bar, we're doing that. They're not getting their green card, they're not getting parole, but they're getting at least something. And we're kind of hope that USCIS does something a little bit, you know, like a little hybrid for us, like they did with the military parole in place. Here we have a question. It comes from Hilda Solis. Husband was caught several times when trying to come in 1998. Didn't see a judge. He's been here since. And then the I-130 petition, which is the petition that is filed by the U.S. citizen. They are referred to as petitioners, and that forms the basis to then apply for a green card. So the petition has been approved. Will he qualify for PIP? He's been married for 23 years, no criminal record. What do you think, Mark?
Well, I mean, you know, a couple of things. We got to look at, again, what we just talked about, the permanent bar here, because when you're talking about trying to come in 1998. So the permanent bar was introduced. It was enacted April 1st of 97. And so we'll have to see, you know, how much time he's had in the U.S. If he was just detained at the border and sent back in 98 and he didn't accumulate the 1 year that is necessary to be triggered after that second reentry, then he might. Now, keep in mind when you said he did not see a judge, Nick had indicated that there are a couple of other mechanisms that could trigger it, and that could be what we call an informal deportation after detention, under Section 235B1. And so that could serve as a deportation. So you didn't see a judge per se, but you were informally removed by the CBP officer. And so when he left, he didn't have to have the 1 year. He could have had the 235B1 removal. And then when he re-entered, he would be subject to this permanent bar. So again, it's good. I mean, on its face, he might be eligible, presuming that Hilda is a U.S. citizen and he's been here, no criminal issues, I-130 petition approved. So, I mean, possibly, yeah. But it would be so important. It'd be so good. I wouldn't say important, but important as well, is to consult with an immigration attorney who could analyze it and look at everything and then see, okay, these are your options, right? Because you had an I-130 petition approved, so you might be going through consular processing, which is the waiver, the provisional waiver here in the U.S., and then through the immigrant visa application. So again, I don't know much about more about the case, but on its face, he could.
Yeah, and in these kind of cases where there's been like a pattern where they entered here in 1998 and they were caught at the border and they were sent back and then they re-entered. Those cases usually result in what's called the voluntary departure, which it doesn't have the same effect as a removal order. If the person was removed and given an order of removal on the border, those are called expedited removal orders. Yep. Those are heavy. So if you return after having after an official at the border had signed an expedited removal order, then there's some heavy consequences and a person is ineligible. But what we've seen in the past, and I'm not saying here, Hilda, this is the situation, is that it's usually somewhat like a voluntary departure. So like Martin said, speak with an immigration lawyer. It might be necessary based on what happened. We'd have to talk to your husband and see what was said, who caught him, what was the understanding. Did he sign some paperwork? Was he fingerprinted? Because it may be necessary to request those records. And we do that through a FOIA or FOIAs. Never once. It's never only one FOIA anymore these days, Martin.
Right.
So it's like multiple FOIAs. Anyway, so here we got a question, and this is from Eli Blake. He's a DACA recipient, and he has an approved I-130 petition. Clean history, other than a deportation that happened in 1996. He wants to know why it's taking too long for the I-131 PIP through a military son. So this is what we're talking about, the military PIP. What do you think, Martin?
You would want to determine the admissibility there, the deportation in 96, to see if that makes him inadmissible for adjustment. I'm not sure.
Well, I mean,
what happened there in 96.
Right. So he through a military son. So he has a son who's in the Army, presumably, or the armed forces. It doesn't have to be the Army. And that could be it. We need to look at that because in the context of military PIP, at least based on our experiences, Eli Bike, if you have a deportation, meaning the judge said we're going to order you deported. I'm not talking about voluntary departures, but I'm talking about the heavy-hitting deportation orders. Those tend to lead to denials, and those tend to have the official or whoever's looking at the military PIP case, wash their hands and say, you know what, I'm not going to give you a military PIP, but there's this other program that if you don't qualify for the military PIP, this is more broader. And the requirements are less stringent, and you can look at military deferred action, which is the same kind of thing as DACA, deferred action for childhood arrivals, deferred action, military deferred action. So it's the same kind of thing. It won't lead to a green card, but it's like it's a protection, a deferral. That's what they call it, deferral from from being deported. So
the military parole would be granted again for somebody, and typically what would happen, we have many clients I've had that were a beneficiary of that, and they were able to go on and get their green cards and then eventually naturalize. But even with such a thing as deportation, somebody would look at it, analyze it, and there may be a way to go back in court to file a motion to reopen now that the I-130 petition is approved. Some good factors. Child is in the military, so it'd be kind of good to look at it to see if there is a possibility of reopening that case and administratively closing or terminating it. So then the person, because you can show to the adjudicator of the PIP that, hey, it has either happened or there's a good chance of happening that removal, that deportation or removal would be, that order would be reopened if this is truly a deportation that happened. So very important to have somebody look at it.
Yeah. So Eli adds on his next comment that he's been waiting for 2 years for the I-131, and that doesn't seem unusual. I mean, we've seen cases that have been longer than that. The reality is that immigration treats these PIP cases, these humanitarian cases, if you haven't noticed, they kind of treat them with low priority, it seems. And some of it could be because they lack the resources, which is one of the reasons why they increased their filing fees in April. So the theory there, right, is to get more people, and with more people, more resources, the application time should be much less. So it remains to be seen. But in your case, Eli, it's worthwhile just taking it to an immigration lawyer such as ourselves, and having a look and seeing if it looks kosher or if it's something off. And I think it's worthwhile doing that for peace of mind. In the meantime, you got Dreamer. You got DACA, I should say, status, which is good. Just keep renewing that. Also, Hilda comments that it was just in addition to add on our prior comment about her husband wanting to apply, but there was some sort of there were some encounters in the 90s, and so he was just detained and returned back to Mexico same day. Those are symptoms. Those are signs that maybe it could be a voluntary departure, which are not that serious in terms of, well, they could be serious, but not as serious as having a deportation order. Those are signs that could be clues, I should say. If the person was caught by Border Patrol, I always ask my clients, do they have green uniforms? How long did they stay? The length of time does matter. In some cases, it's longer. They're processed, or they're charged criminally. Sometimes they're taken to a federal magistrate, and they're detained for months even. But those are signs. But I don't think it's a good idea just to rest it on clues, right? I think it's worthwhile to see what exactly happened, because immigration, we don't like to go when we file an application for a client. We don't like to go with our eyes shut. We want to know what happened. We want to be able to address the person's history. Sometimes immigration will contact us and say, hey, your client has this or this or that. We want to know what happened so we can address it, and we could advocate a position for our client. But thanks, Ildo, for your question. So let's talk about, we have another question, and this is from Franca Henares. I want to say that you made a comment on the Spanish show, but thanks for watching. I appreciate that. Make sure you subscribe. This is what we were talking about. Does the person need an informal license to show for the proof of common law marriage? And just returning back to that requirement for parole in place here again with my dopey chart here, right? Married to a U.S. citizen, and I should say married, have a legitimate marriage, right? You can't be married to more than one person at the time. So married, and what does marriage mean? And USCIS has said marriage is what your state law says, really, essentially. I mean, if it's legal in your state to have a common law marriage, then immigration should respect that. But you have to meet the requirements of a common law marriage, where the marriage or the relationship was formed in the state that you reside in. In Texas, you could apply for an informal marriage certificate. And I say there was a couple advantages of getting an informal marriage certificate over the other alternative. The other alternative is to do the following: is you talk to an attorney, you go over the requirements. If you meet the requirements for common law marriage, then you could get all those you can get the documents, the evidence to show that you were living together, that you had agreed to get married, and that you represented to other people. And you can get that evidence and make the argument with USCIS. Okay. Now, USCIS, when they get your application, they're going to be looking for that marriage license. So they're going to be looking at the packet. If it's not there, they're going to be scratching their heads. They'll be like, okay, where's the marriage license? Oh, no, we're making an argument that this is a common law marriage, and here are the evidences. This is the law. This is the statute, the Texas Family Code that says common law marriage. And so you'll have the officer look at that and probably talk to their supervisor and the supervisor's supervisor and see if you meet the requirements. But there could be pushback. They might do what's called a request for additional evidence. They might ask you for the license. But so I tend to, in these cases, I tend to tell my clients, you know what, to avoid that back and forth, that head scratching, maybe it's better just to get your marriage, your certificate, your license of informal marriage, as opposed to having to prove the case before USCIS. But what's your opinion on that, Omar, Martin?
No, of course, and that I agree with that, and we do that in other types of cases again, because it's there's likely to be a request, likely to start digging into taxes and did you even consider taxes, and were you supposed to file it married filing jointly or married filing separately, and if you didn't, do you have to go back and amend them? And so like you had mentioned, you go in, you request it, it's fast, there's nothing to it, and you get the certificate of informal marriage. You select on the date that fits perfectly to what you're trying to accomplish in terms of meeting those state requirements, and you provide that. It's always I'd say something that is
And it's my client recently uploaded a document, and that was the informal marriage certificate, and he said it was pretty straightforward. So it could be time saving in the long term to get that, as opposed to having to argue and show evidence and have that back and forth. But anyways, thank you, Frank and Adis, for your question. We appreciate it. We have a case here, and this is from Uno Mikey. He has his National Visa Center case August 3rd, and yesterday got approved. What's the next step? It's a Colombian spouse visa. Should I wait for the embassy to reach out to me, or should I email? So I'm thinking, well, the embassy, we need more information, Uno Mikey. The embassy means that you're going to get the green card or the visa interview, immigrant visa interview outside. And you mentioned the embassy. Congratulations. If the I-130 petition if we're just talking about the first step, which is the I-130 petition, okay, this is where a person lays the foundation. And how I describe it to my clients, I sometimes, a lot of my clients are, they work outside. They're hard workers. They work in construction. So I kind of say, look, it's like when you're constructing a home. This is the cement. This is the foundation. This is the concrete. Okay, this is where we're showing that you do have sponsorship. You do have a family relationship. Your wife is who she is. She's a U.S. citizen. You have the relationship. This is what you're saying. You're not saying at this point that you are eligible for a green card. yes, if you noticed on the first step when you file the petition, the I-130, they don't even ask you about your criminal background. They don't even ask that many questions to the beneficiary. It's more driven to the petitioner, the U.S. citizen or legal permanent resident who's petitioning the beneficiary, who's going to be the applicant for the immigrant visa. And so, go ahead, Martin.
No, I'm just saying, I mean, it's just like, it's a spousal visa. It's a spousal petition. It was just approved in August. It was probably pending for several months. So if, or when PIP is enacted, you might be a candidate. So you may not have to go out, because this could be probably another 8 to 12 months or so. It's Bogota. And so, it might be an option, right? So you may not have to go.
Yeah. Yeah. And this is it might be an option for parole-in-place if the person is here, physically present, the beneficiary. So I kind of read that, and sometimes we have clients who are waiting outside, who are currently outside.
Okay. Well, then, should I wait for the embassy to reach out to me, or should I email them? Yeah. So, yeah, that's true.
We'll need more information, right? Parole-in-place, just to remind everyone, is for people. Parole-in-place, this new program that's being proposed, is for people who are physically here. That's correct. All right.
But
so,
assuming you're watching us from Colombia, if you're outside, that's great.
All right. So Eli Bike, he asks, he provides more information that we received a year out of mail. Yeah. You could, this is the military PIP, and I think the military PIP, I know that the military deferred action, they changed the address where you submit that. I think it's in California now. I think the military PIP might be in the field office where you live, in the Immigration USCIS district office where you live.
Yeah.
And if it's taking too long, nothing prevents you from saying, look, I'm going to write a letter, send it in and say, hey, what's going on? It's taking a lot of time. You could even try an info pass to kind of schedule with immigration and say, why is it taking so long, and do an inquiry that way. Okay, so thank you, Eli. Make sure to hit like and subscribe. And here we go with Muñequero. They are, so the 601A waiver process was started this year, or I should say she started this waiver process this year in January. The new president decides to eliminate that category. What happened? Well, I don't really understand the question, but in terms of people who are applying for this waiver, let's just talk what's a 601A waiver, because a lot of people who are interested in the parole-in-place are in the process of trying to get a green card as we speak. And if for those who are in the process, let's just this parole-in-place, let's just leave that aside. Let's just pretend it doesn't exist. For those who have to apply for a green card, who had entered without inspection, and there are some exceptions, they have to go through this process called the consular process, and it involves 3 steps. First, you have the laying of the foundation, the concrete, the cement when you're constructing a home. That's the I-130 petition. That's the base petition. That is filed with the USCIS. This is where you're showing the government that, look, I have a U.S. citizen or lawful permanent resident petitioner, and this is proof that we have a relationship. Nothing more. Once the petition's approved, then we go on to the second step. The second step here would be, or the second stage, if we're doing the analogy of the home, the second phase of the construction. I get lost on my analogies all the time. So the second step would be that waiver, that provisional waiver. Why do you need a waiver? Well, you need a waiver because the law says that if you enter the United States, and stayed here for a certain period of time, it's usually 1 year, but it could be also 6 months. If you stayed here and accumulated what's called unlawful presence, if you leave the country, you're going to have this 10-year bar. And so this is for the unlawful presence that you have accumulated, and to get that lifted, to get rid of that waiver, they would allow the immigration allows you to file a waiver application ahead of time. You could do it while you're here, so that way when you leave the country, you're not going to be barred because of the time that you spent here without any documents. And that's what they call a provisional waiver. And it has to do with, and to get it, you have to show hardship to a qualifying family member. So that's the second stage. And a lot of people are asking, right, Martin, like, what do I do if I'm at this stage and all of a sudden the president announces this new program? What should I do?
Well, you basically have to see how far along in the process you are. Because if PIP somehow gets introduced but challenged and the provisional waiver gets approved, that's your second step. And then you are basically completing that immigrant visa process, which is entering the third phase, which is completing the immigrant visa application at the National Visa Center at the NVC. And then once that is completed, the final sub-step of the third step would then take place at the consulate. So it's just kind of freezing everything in place and deciding and determining, what's going to be more advantageous. The PIP, the parole in place, was announced for family unity, so people wouldn't have to leave, because even though the provisional waiver gets approved, it's going to waive your unlawful presence, but you still would have to go and process your immigrant visa in your home country at the U.S. consulate or embassy, thus leaving your family behind, leaving your work behind, and whatever else you have here. And so if PIP, if the parole is enacted, isn't challenged, and it could get adjudicated within a few months, then you don't have to go anywhere. Once you are granted the parole, you would apply for the green card. So always just doing the assessment is the most important thing, and we'll see, because as soon as we're going to see some challenges and we have somebody who's been approved for the provisional waiver and the case is clean, we may just as well finish that final process, that immigrant visa process, through the National Visa Center.
Yeah, good point. All right, so moving on, we have another question. This comes from Marvin, YouTube. What about someone with a deportation order in absentia 20 years ago, never left the country, and a DUI over 10 years ago? An I-130 has been filed 2 years ago. Will this qualify me from PEP? So let's go with the PEP, what we know so far, right? So me and my dumb chart.
Don't call it dumb.
All right.
It's nice.
So you entered the United States without inspection. It seems like you did, right? So number one, if you're married to a U.S. citizen as of June 17th, you could qualify. Looks like you've been here physically present for 10 years, right? Now we get into the question marks. The question marks we don't have any answers for, not because we're dumb, it's because USCIS has not shared that information with us. So we're still waiting for that information. They said no disqualifying crimes. We don't know what that means. Could it be DUI? It could be. We don't know. So it's something that we have to keep an eye out. Admissible. Another thing we talked about, right? When we talked about the permanent bar, are they going to also tell us that that our clients have to meet the requirements to get a green card in the first place? Does that mean, because people who have a deportation order, generally speaking, they can't, it's not like if you have a deportation order, it's not like you can apply for your green card directly with USCIS. In most cases, you're ineligible. So if those grounds apply here, then we might have to look at trying to perform some surgery here, meaning we have to look at what happened with your in absentia removal order, see if there is a way that we could open it, right, and talk to the judge and see if it's a way we can dismiss it or terminate it, so that way you don't have any there's not any lingering impediments in getting your green card. So it's a surgery, and we often describe ourselves, Maria and I, as surgeons, because sometimes we get referrals from other colleagues and attorneys, and there are difficult cases. People have been deported for over 20, 30, 40 years sometimes. And it's like we're trying to see if there's still a pulse in there, right? And if we can salvage it and resuscitate it and to see if we can help, or if it's a dead on arrival. But here it looks like there's some life, Marvin. We just need to look at your case, and I think it's worthwhile having someone check it out. Now, if you have an attorney, that's great. Speak with your attorney. If you want a second opinion, we could also look at it. So it's up to you how you want to do it. But we can't answer your question about PIP just yet until we get more information from USCIS. All right. Let's see here. Yeah, so Frank, in extension to the question he had about common law marriage, there's some things that we don't know, we can't say over through the internet. We have to, Martin and I value our license. We don't want for you guys to think this is legal advice that you can take to the bank. You have to get it looked at, just like if you're feeling sick and you're looking at symptoms, you're going on the internet and you're looking at to see if you have a certain condition. Yeah, we don't do that. We want you guys to go and get the situation looked at thoroughly before we can give you advice. But just to answer your question, it seems like you're on the right track, and you could also get in contact with us. We'll be happy to speak with you. And Marvin adds to his question that his DUI, he has complied with the court orders on his DUI. That's great. A lot of times, our clients who are applying for an immigration benefit, they come to our office and they say, "Look, I was arrested for X. But I've completed it, and the court said I no longer have a conviction. It's erased from my record." And my attorney, my criminal defense attorney, also said, "Hey, it's as if it didn't exist, But for purposes of immigration, they're going to want to know, were you arrested, regardless of whether it was dismissed or they call it expunged or deferred adjudication. They in fact, deferred adjudications considered a conviction, not under Texas law, but in federal immigration law it is. So they want to get that information. So when they ask you about your record, it's important to give them the full picture, the full panorama of what happened. And that's arrest. Even if it was expunged, that's great. If there are no court records available, you can get a letter or a clearance letter from the clerk saying, "Hey, there's the cases or the court documents have been destroyed," and that would also work. This question comes from Yadira. So the 601A waiver that she filed, that second step that we were talking about, is filed and nothing has happened. What can she do about the situation? And can she apply for PIP? What do you think, Omar?
Well, 4 years. I mean, it's one of those that are taking a long time. I think 4 is the longest I've seen on the provisional waiver. We've seen 3.5 to 4 years. So it's getting close. And what I would recommend is check to see if it's been within the processing times. And if it's outside of the processing times, is to submit an inquiry. But you may be getting close. At the same time, evaluate to see if you potentially would qualify for PIP for the parole-in-place. And then go that route, right? But it seems like if you had been heading and you are heading down the consular processing of your immigrant visa under the provisional waiver, everything seems to be in place. You should meet the requirements. So if you have an attorney, make an inquiry. You could make an inquiry yourself just to see what's going on with the processing, just to make sure that it hasn't fallen through the cracks, that somehow there wasn't a decision and you didn't get it. But 4 years, it's getting up there. I think that's the most I've seen, 4 years. But typically it was 3.5. And the goal of the USCIS is to get it down to 10 to 12 months, as it used to be pre-COVID, because it kind of ballooned to 3.5 to 4 years of processing. So I think you may be very close to getting a decision.
Yeah. Yeah. And it's worthwhile to look at parole-in-place. That could be an option too. And Yadira asks, how much the PIP cost? Question mark, Yadira. We don't know yet. Those are the things. And this is why did immigration do this? They announced something so great, right? And then they don't give us information about how much it costs or what the process will be or what the forms will be, and until it looks like they're going to give it to us sometime next week, right before they give us the green light to file it. So this is a sign, right? This is a sign that and this is like when with the parole programs that we saw with nationals and citizens of Afghanistan and Ukraine. This is how what we call in legal terms half-ass, and it's political. We know that, and so when something's done like that, there's going to be some question marks. There's going to be gaps. People are not going to know exactly what the requirements will be, and I suspect that some of the officials at USCIS don't have that information yet, and so it's going to be interesting. This is why I think that it's important to know that the best approach is the wait and see approach right now, and say, okay, what I know for sure are these facts. I know for sure that it applies for people who entered without inspection, married to a U.S. citizen, great. 10 years physical presence as of June 17th, great. So at least I know that those are the basic requirements. I could start looking for evidence that was here the last 10 years. Nothing prevents you from doing that. You should. Getting your marriage certificate in order and all that. Well, we don't know yet, right? But don't get your hopes too high, because we don't know yet about the disqualifying crimes. We don't know yet about these other issues about permanent bar until immigration gives us more information. So, subscribe. Again, I sound like a broken record, but subscribe so that way you'll get that information. Once immigration posts it and publish it, Martin and I are going to be studying it and dissecting it, and then we'll talk about it, and we'll have these shows where you can pose your questions again. Thank you, Yadira. Let's see here. Jason Bourne, part 2. This is the part 2 question. So he wants to know if it's going to be a shorter process than the I-130. We don't know yet, Jason. Again, those are the question marks we have. We're just like, why did they do this? They announced it and they didn't give us information. So we just have to take. Well, what do you think, Martin? I mean, given our experience,
look, he already. I mean, if and I'm not sure if I recall Jason's fact pattern, if he had an I-130 petition approved, but if that's so a parole would be the step to make you here as if you entered legally, as if you were paroled in. And then the second step is adjustment, which consists, if it's a one-step adjustment, the concurrent filing, it's the petition and the green card application. Petition from the petitioner, from the sponsor, green card application for the applicant, for the foreign nationals. So because it is through a sponsorship by an immediate relative, by a spouse, citizen spouse, it allows for concurrent joint filing. If the I-130 petition was approved previously for the provisional waiver process, then once you get the parole granted, all you have to do is the second step, which is the green card application, right? If it hasn't been filed, then you do the I-130 and I-485, the petition and green card applications together. And recently, for the new cases, we have been seeing, I just saw one today at 47 days. Marriage-based adjustment, which is just out of this world. Even I think we've seen something shorter. But typically it was 10 months, 12 months, 18 months. Now, I don't know what's going on. They're trying to clear the backlog. So the question is, how long will the parole-in-place take, right? If it's not challenged. So if it's going to be 2 to 3 or 4 months, and then you have adjustment of status another 4 or 5 months, yeah, you have a clear winner. That's the adjustment of status in the U.S. You don't have to go anywhere. You don't have to buy tickets or drive down there and get a hotel room and everything else. Yeah, if it looks good and if it looks solid, I'd say, stay here. And I think anybody would. If it was me, I'd probably stay here. If my family was at stake, I want to stay here and see what happens. Now, if all of a sudden there's a challenge, there's a pushback, there's an injunction, and there's a lawsuit litigation going on, and I have a solid provisional waiver case, or it's been approved, then I'm kind of making the decision with my attorney and deciding, okay, which way should I go, right? And that's got to be kind of like meeting with your with your doctor, sitting down and analyzing and looking at all the facts. And that's basically what we would do with any of our clients or prospective clients.
Yeah, you weigh the good with the bad, and you figure out, look, this is a great program. This is great, but it's not foolproof. It's not something that is stable. In my opinion, it's a good idea and it's a good process. And if you're eligible, you should look into maybe filing it. But there are a couple things that you mentioned there. Look, the top 3 things that could torpedo this, I think, is number 1, we know litigation. Now, our colleagues, there's some pundits who are looking at this, say, yeah, but parole is going to survive it. It's the authority of the executive. It could be, but given our experiences and our observations with DACA, there could be a lot of stop and go and that. Number 2, the elections. All right, this is a creation of the current administration. We know that next, if we have another administration, I think you guys know what I'm talking about. It's very likely that these types of pro-immigration policies will be pulled. So that's something to also consider. And then 3rd is what Jason referred to in terms of the processing time. We don't know, how long the resources. Like, in my opinion, is this was sort of half-assed, right? And so with that, you're not going to have the resources maybe ready for, I would imagine, a lot of people applying for this. And we've seen that with other types of parole programs. So it is possible that it might not be as quick as we would like. But I could be. I hope I'm wrong. These are the things that I hope. We attorneys hate to be proven wrong, but I would want to be proven wrong on this. All right. So this is a question of. This is one for you, Martin. So he has a R1 visa. Mark Santana. He writes from YouTube. He's going to apply for his green card soon. He has double citizenship. His visa on Spanish passport, so he looks like he's a Brazilian and Spanish, and wants to get more information. But it looks like we need more information, don't we? But he does write here, for my green card, they look where I was born and can take long if I'm Brazilian. So this is one of those things where should he apply as a Brazilian or Spanish citizen?
Well, can you apply? So in terms of the weight for the green card, it doesn't really matter because it's you are not from one of the individual countries, Brazil or Spanish. So you are all areas of chargeability. You basically, I believe you would go with the passport you've been admitted into the United States under. But in terms of, I don't know if I understand the question perfectly. Sometimes, so you may have an Indian national who has to wait for a green card for 12 years because India is one of those countries that is backlogged. But that person becomes a Canadian citizen. So, in fact, I had a consultation like this last week, and they said, like, well, hold on a second, I'm a Canadian citizen, so I don't have to wait those 12 years. I can just wait in that category maybe another year or so. And unfortunately, the area of chargeability, the country of chargeability, is the country of birth. And sometimes you can charge it to your spouses if the spouse is from Canada, for example. But if the spouse is from India, then it goes to that country. So I think in your case, it doesn't matter, but I'm sure you have an attorney who is assisting you or a law firm who is assisting you. So I would defer to them. Generally speaking, it's the passport or the nationality of admission. If you're asking, in what nationality should I be applying under, but not area of chargeability, because it doesn't matter.
Yeah, and what we're talking about, what Martin's alluding to here is we're talking about this visa bulletin, and in some cases, people who are citizens of more than one country, they can look at using the country that doesn't have a long wait like these countries, right? So people who are from Mexico but are also dual citizens of Spain. I'm not going to say I'm Mexican. I'm going to say I'm here because of that, and I think that it's good. But that's if we're talking about family based, and so obviously we'll need more.
Because this could be he's an R1 religious worker, but he could be an R1, but he could be marrying a U.S. citizen. So I don't know. But if you have other questions, Mark, just feel free to reach out to us.
All right. So we got another question here, and this is an employment-based question. Is Serene Haddad. He's in the U.S. with an F2. F2 visa is a dependent of an F1 student. So there's a person who's going to school here on an F1 visa. That's what you call it. And maybe bringing in spouse or children. There are F2 dependent visa. I think that's what it's referring, because it could also be the family base, but we'll see. And he's a EB3 unskilled workers process. What do you think, Martin, taking this question?
So what's the question though? Is it possible to be current in 2025? We don't have a country of chargeability here, do we? So I'm not going to be guessing based on your name, because it could be anything in terms of. So if you scroll up, so you would go to the dates for filing. If you're in the U.S., typically that's the one. But every month you'd have to check which if it's going to be the final action dates or dates for filing. So if you scroll up, scroll down to the dates for filing. We don't know the country, and as you can see, other workers, we have January 1st in 2021, and you are September 13, 2022. So could it be current next year? We'd have to see whether and what was the speed of the priority date moving for the last couple of years. It's really difficult to tell you if we're gonna get there. Would I say January of 2021? Possibly, but it's really difficult to say if it's going to be current in 2025, presuming that you are from the
he's from Algeria,
chargeability area.
That's
right?
What he mentioned. He's from Algeria. All right. Well, it's over an hour mark, and we appreciate that your questions, and we'll do this every week. And if you have another question, or you missed something, you could always send us a message. You could also schedule an in-person or a virtual consultation with us, or one of our immigration attorneys. Martin and I will be glad to help out with that. But we know that we have to wait for more guidance. Basically, that's the lesson of the story today. Until immigration publishes more information about the parole-in-place program. And as a reminder, we have information on our website and our channels about this parole program, where you will find informative posts. You'll see on the feed. You'll find it there where we're checklists and questions and answers, at least from what we know, and we're going to update that information along as well as the website. And most importantly, don't forget to subscribe. Very important to stay on top of these updates as you are witnessing here. And just take care of yourselves. Martin, any concluding words here?
No, let's just wait patiently for next week. Hopefully we'll see the forms and more guidance drop, and then we'll be here to answer your questions. Of course, in all of these channels, you can find our links, whether it's the consultation links or how to reach out to us. So please do that. As Nick said, like and subscribe so we can reach the 5,000 followers and subscribers on YouTube. And we'll be here answering your questions in the days to come. Everybody have a great weekend.
Thank you, everyone.